Before this courtroom exchange even begins, understand what's really at stake here. This isn't just a routine plea deal, this is a defendant with years of criminal history standing before a judge who has already read every page of it. A 4-year deferred probation hangs in the balance, thousands of dollars in restitution are on the table, and one wrong move could turn freedom into jail time. Watch closely how quickly this hearing shifts from procedural to explosive. Because what starts as a standard plea discussion spirals into a full courtroom breakdown that no one saw coming.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, I have.
And any additions or corrections or?
There's a lot of history we understand, Your Honor, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows the restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Oh.
This is the moment that changes everything. When the judge mentions 3 1/4 pages of criminal history, that's not courtroom exaggeration, that's a red flag the size of a billboard. Judges weigh criminal history heavily when deciding whether someone deserves leniency, and here, we're not talking about 1 or 2 old mistakes. 14 felonies that weren't dismissed, multiple misdemeanors, and ongoing probation elsewhere? That instantly shifts this from a mercy conversation to a credibility problem. Put yourself in the judge's seat. How much trust would you have at this point?
Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed, at least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I'm continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this?
This is a brutal reality check. When the defendant brings up nursing school, the judge doesn't just question the timeline, he questions feasibility. In healthcare, criminal background checks aren't optional, and offenses involving theft and fraud are especially damaging. This isn't the judge being cruel, this is the judge being realistic. Courts don't operate on intentions, they operate on records. And when your record contradicts your future plans, credibility collapses fast. Do you think the court should factor in aspirations, or should the past speak louder every time?
The criminal history?
These are that I haven't been convicted of. I'm a CNA now.
Where do you live now?
In Houston.
Another issue that I see on here also is the restitution, because it shows $9,400, but then that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I guess, a bank fee.
Well, it says $500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was
$900 that it's in the bank.
I wasn't aware of, Your Honor, when we did it and when I got the PSIs, when I was notified, I was in the cash wrap. But if there was a withdrawal, then that would be her responsibility joint and separately.
Right. It says, so
Just a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM.
Here's where the financial reality locks in. Whether the money came from inside the bank, an ATM, or Cash App doesn't actually change the legal responsibility. The judge makes it clear, if you were working together, you're equally accountable, even if someone else physically withdrew part of the funds. Restitution isn't about intent, it's about loss. And now the number jumps from $9,400 to a full $10,000, making this plea deal heavier than the defendant likely expected. At this point, the margin for error is shrinking fast.
And 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the status of another person. This is one that was in charge. I'm not there, coaching on there. But.
Okay.
She was responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's okay. Apparently the cops didn't either. So.
She went in the bank. She was in the hospital. Well, I'm not telling the fact it's not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County. Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern. The state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
All right, so here's what I'm going to do, Ms. Vogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
Excuse me.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you do.
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back here.
Okay. You have lots of them that were at the same time for different offenses. Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit. And that's the 10-year probation that you're on in 5 different cases. That's not correct.
No.
So how many cases are you on probation for in Sutton County?
It all ran together. So.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks.
This is the turning point. The deal is dead. Judges are not required to accept plea agreements, and when criminal history mirrors the current charge, leniency becomes nearly impossible. 14 prior felonies of similar conduct tell the court one thing: patterns matter. When the judge rejects the agreement and resets the case, it's a warning shot. 3 weeks isn't a delay, it's a final opportunity. And notice how quickly frustration replaces negotiation. This is where courtroom discipline becomes just as important as legal strategy.
We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
Not matter. My life's on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her. Don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
So my lawyer, he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either. You did.
He got me.
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my dog and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse.
This reaction costs her dearly. Judges have wide discretion when it comes to bond, and courtroom behavior is a massive factor. Cursing, interrupting, and blaming counsel doesn't just look bad, it signals instability and risk. The judge explicitly ties the bond increase to attitude and criminal history, and just like that, freedom becomes far more expensive. This is a textbook example of how emotional outbursts can override legal arguments in seconds. Would you have handled this moment differently, knowing everything was already hanging by a thread?
When I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
You want to push on me like that? You don't want to put this on me like this. I'm not going to do it like this. I'm going to do it like this.
In the end, this case is a powerful reminder that plea deals are privileges, not guarantees. The judge reviewed the evidence, weighed an extensive criminal history, rejected the agreement, and ultimately raised the bond due to courtroom conduct and credibility concerns. What could have been deferred probation now risks becoming incarceration, not because of one mistake, but because of a pattern reinforced in real time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns where every word, and every reaction, matters.